You've been in jail for 19 days. What's left is a trespass from the city of Sturgis in file 25522OM. That allegedly occurred on March 19th. And 25541, that occurred on April 9th. So they keep charging you with trespass, you keep not showing up, then a bench warrant issues and you got picked up, and now you've been in jail for about 19 days. Are you gonna enter a plea to 2 counts of trespass? Sturgis thinks that they can solve the homeless problem by continuing citing people with trespass, but that's the deal here. They're gonna dismiss 2 cases and you're gonna plead to 2 cases. Is that right?
Yes.
Anybody threaten you to get you to do that?
No.
Or promise you anything?
No.
You understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or a jury.
Yes.
If you had a trial, you'd have the right to take a witness stand and testify on your own behalf. But if you didn't wish to, they couldn't use your silence against you. You have a right to have a lawyer with you, and Miss Yancey's been appointed. And you have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
These might all run together for you, Mr. White. It might be hard to keep them separated.
And Your Honor, in file 25541, that the report I have says March 22nd at McDonald's. I don't have an April 9th report.
All right.
He had an appearance ticket for April 7th from the March 22nd. So I don't know if that's
522 is March 19th.
correct.
541 is April 9th, it says here.
I have March 22nd at
Well,
McDonald's.
let's look at the actual case. 541. Oops, wrong guy. Yeah, it does say March 22nd at McDonald's. Were you at McDonald's that day and they told you not to come back there?
I'm not sure because I lost the paperwork.
But at some point McDonald's had told you not to come back?
I think so, yes.
All right.
And Your Honor, he was sentenced on Tuesday of this week by Judge Pattison to 17 days in a use of meth and indecent exposure case. So
Yes.
he's serving time on that. We'd ask any jail time be concurrent with that or time served.
All right. $19 credit, 19 days, minimum allowable fine of $125 or 2 additional days. Concurrent with all else. All right, the other one is that 522? 22. That's 541. All right, let's look at the other case. Five two two. In that one, it was at Bright and Clean on March 19th. Were you sleeping in there?
No,
What, you'd been barred from there too?
yes,
Now it's rough being a homeless. Have you got any people?
no,
What are you gonna do when you get out? Be back in the soup?
probably.
Yeah, we don't have a good solution. People, there are a lot of homeless people in Sturgis.
Yes,
And
sir.
they're camped out in certain places and they're assaulting each other and stealing from each other and sexually assaulting each other and making a mess of things. And they aren't there because they want to be. They're there because they're homeless. Do the same thing, 19 days credit, 19 days, minimum allowable fine of $125 for 2 additional days, concurrent with all other cases. I don't know what your out date is, but this one will be served at the same time as your other ones. So you're good to go, sir.
Thank you. So once you're done with the other case, you can see what time so you have about a week left on your case. Okay. About 2, right? You're welcome.
All right, now we'll do Mr. Deonte Williams.
And Your Honor, an update to the sheet, he is gonna make an admission on a bond violation today, but asking for last pretrial and then underlying misdemeanor.
Okay. Well, we'll have lunch a little late today. A little short. Right. Good morning, sir. Sorry
Good
it
morning.
took so long. We've been working steadily here. Ten days. Angelique, I don't know what I'm gonna do about those Luke Nossinger cases. I have to figure it out.
I have been communicating with Mr. Knopfsinger upon my review of our files, and I have requested him to speak as soon as he can to his clients in hopes that we can get a resolution or a response back to the court in some fashion.
He must have excused them all. None of them showed up, so I'm not sure what happened. I'll just set those aside, but I'm concerned because several of them are in custody. All right, this matter is 251626. People versus Deonte Williams. In that case, Mr. Williams is charged with assaulting Ava Mae Calvin on or about August 10th of 2025. The bond conditions were that he was not to have any contact with Ava Calvin or engage in any assaultive or threatening behavior. The allegation was on August 24th, he was at Ava Calvin's, and they found him hiding in the laundry room. At Maple Crest. There's also a PPO in place. There's also a new case.
Does the record show he's been served with that PPO? This is news to him.
I don't know.
I'm going to send Miss Calvin.
Probably nobody's upstairs. The new case alleges that on August 26th, he did a home invasion at Ava Calvin's house and did assault with intent to do murder by strangulation and a new count of domestic assault. So he got out of jail and he got rearrested on the same thing. So this charge is the August 10th matter. It is, I think, set for an attorney pretrial today, and they set the bond violation. What's our status here, Ms. Harden?
Thank you, Your Honor. We are going to be requesting last pretrial for the underlying charge of domestic violence. I've talked to my client, advised him there's a bond violation hearing set for today. He indicated to me when we met in lockup that he was willing to make an admission as to the bond violation as it pertains to contact. However, I will be mindful of that because of the pending case that has subsequently been filed.
We
So
could do it by no contest.
I would,
Your Honor, if I can assist, the particular bond violation that is currently before the court is not the underlying factual scenario for the new case.
All right.
So it does pertain to his bond, obviously, but it wouldn't necessarily be any statements used against him in the new matter. Although, come time of trial, if that case does go to trial, there may be some other acts evidence that could be utilized. So
This is the laundry room incident?
Correct. And my information is that laundry room is on the floor of the apartment of the victim. It's like in her hallway.
Yes. All right.
and Your Honor, I more so was saying that just to kind of advise my client about how much he says so he doesn't delve into the facts of the other case.
Well, why don't we just limit it to that? On that day, Mr. Williams, were you at the complex where Ava lives?
Yes.
And you were in a laundry room outside of her apartment?
I was actually doing laundry though.
All right. Did you have contact with her?
No, I did not. She seen me out the window. Well, her mom pulled up to the apartment and seen me in the laundry room. And she said, "You're not supposed to be here." And I said, "I'm just doing laundry. Can you please just calm down?" And then she said, "You need to leave." And I left.
All right. Why did you go there to do your laundry?
Because that's where I lived and before that, and I didn't have the money to go to the laundromat, and like all of my clothes were basically in that vicinity already. I was completely unaware of any PPO or anything like that. And I have not been contacting Ava. She's been contacting me.
All right, well, I don't know about that, but she's not to call you at the jail. We've had this before. There's a PPO or bond condition and the inmate and the complainant are talking on the phone. So she's been contacting.
No, I'm talking about when I was in the free world, and I didn't know that was a thing either. You know, I thought it was just a bond condition that we weren't allowed to have contact if I was on bond.
I do believe there is a PPO. They were concerned because you'd gotten out of jail and this new assaultive case sounds bad.
Yeah, I have
All right, don't say any more about it.
the new case, or
Don't talk
The
about
new
any
case.
cases.
I was just talking about the PPO. I was like completely unaware about that. So
Well, we'll see. We can get a copy of it served on you at the jail.
do you know who it's against by chance?
I don't have it here. Let me, I
I'm
bet if I call upstairs, there probably isn't anybody there.
Gonna check the ROA real quick, Your Honor, and see if it's in the system.
We're open during lunch. I don't know whether the clerk is.
I don't see one.
I think I did it. Hi, Melissa. Sorry to bug you during lunch. I'm still on the bench. Is there a PPO against Deonte Williams? Yep, Deante. Ava Kelvin would be the petitioner. So there, all right, I would have sworn there was a PPO. Okay, all right, thanks. Bye. They're not finding a PPO in the system.
I didn't see one either, Your Honor.
So apparently there isn't one, so I won't worry about serving it. All right, I'll accept your no contest plea to the bond violation.
Do have a lot going for me in life, so
Yes?
yeah, I paid child support for my 3 kids. I pay on my car payment that I'm gonna lose if I sit in here.
Yes, that's all. Let's see where the new one is.
It's set for Tuesday, Your Honor, for PCC.
All right. Now there's another
Even if
one.
I have a tether and just work so I can maintain my life.
Where were you working?
International paper.
Well, we'll discuss that.
I don't have any problem abiding by my bond conditions.
But you have another one. Gee whiz, this is 2020. That's on Tara Conklin in Baroque. It was charged as a felony.
That was a felony?
Yes.
I thought that was a misdemeanor.
Well, it was resolved as a misdemeanor.
Yeah, I took a plea for that because we were at court for 2 years trying to figure that out during COVID and stuff.
Well, that was an child in common child abuse, 4th degree. Why does that have a FY number?
It's supposed to be non-public.
Yeah, it's public to
Security
me.
clearance.
All right. Well, I'm gonna give you 5 days jail credit. 5 consecutive. consecutive to the underlying charge. Means you're gonna get 5 extra days.
And this case is resolved.
What, this? So I gotta sit for 5 more days for this case.
After this case is resolved. Yes.
All right, PEC is set for, gonna be real busy next week, 9 on new assault case. And we'll set the last pretrial on a Thursday. So I'm sorry that hopefully they held lunch for you guys, but you're good to go.
Your Honor, if I may, I'm gonna look at the other notes I had. I attended Mr. Williams' arraignment on the new offense. I just want to make sure that there's.
I thought the bond was like $75,000.
60,000.
It's a 60,000 cash or surety, and it does indicate that if he is bonded, pretrial services must tether him before he's released.
All right, that makes good sense.
There's no way it can get reduced.
Well, we can discuss it on Tuesday.
Okay.
The
I can tell you
allegations are
now,
not good.
Your Honor, I'm going to remain on these cases, and I will not be in an agreement with any bond reduction from my office's perspective.
Yes, you were on bond for assaulting her. There's an allegation you went over there.
It should be a home invasion and an assault, great bodily harm, and domestic violence, Your Honor.
So
My family also says she's called you multiple times.
all right, well, that's between them. The charge isn't Ava Calvin versus Deonte Williams. It's the people of the state of Michigan versus Deonte Williams. So she can give input, but the final decision is up to them. And I'm of the same mind they were when I was prosecutor. If somebody's on bond on a domestic violence and gets arrested on a new domestic violence, we treated it very seriously. All right, you can go with the court officer and I'll see you on Tuesday. Bear in mind, they're gonna oppose any bond reduction.
Thank you.
Thank you, Your Honor. If I hear from Mr. Knopfsinger, I will let the court know.
All right, I've got a very busy landlord tenant afternoon, so I'll be here, but I'll be on the bench.
If you want to turn the live feed off, I don't have much information, but I
All right.
have some.
All right, let's talk about that. Judge Middleton's docket here gave us a pair of cases that highlighted both the frustration of chronic homelessness in small towns and the serious consequences of ignoring bond conditions. First up was Mr. White, a familiar face in Sturgis, charged yet again with trespass. He'd already been in jail for 19 days, and this time the plea deal was simple: plead to 2 trespass cases, dismiss 2 others, and get credit for time served. The prosecutor confirmed one incident was at McDonald's, where he'd been told not to come back, and another at the Bright and Clean. White admitted he wasn't sure about the dates because he'd lost his paperwork, which pretty well sums up the cycle he's stuck in. Middleton took the plea, gave him 19 days concurrent, added the minimum fine, and noted, almost warily, that Sturgis keeps trying to solve homelessness by issuing trespass tickets. He even acknowledged the rough reality of camps in town where people are assaulting each other and stealing from each other, pointing out that no one is there by choice. The whole exchange was equal parts sad and practical, Middleton doing what he could with the tools he had, but openly admitting the system doesn't offer much of a solution. Then came Deonte Williams, and the stakes were far higher. Williams was already on bond for assaulting Ava Calvin with a no-contact order in place. The violation at issue this day was him being found in the laundry room of her apartment complex. Williams insisted he was only there to do laundry because his clothes were already in the facility and he couldn't afford a laundromat. He said he hadn't contacted Ava, that she'd actually been contacting him, and that he didn't even know there was a PPO in place. The judge checked. Turns out no PPO had been entered, But the bond violation was clear. Middleton walked him through the admission, limiting it to the laundry room incident to avoid prejudice in the new case. Then he dropped the heavier news. Williams had just been charged with a new case alleging home invasion and strangulation involving the same complainant. Middleton gave him 5 extra days in jail, consecutive to his other cases, and reminded him that bond reduction was not on the table with those new allegations. The tone was serious, direct, and cautious, ensuring the record was clean while making sure Williams understood the gravity of his situation. The atmosphere between these two cases couldn't have been more different. With White, it was weary recognition of a systemic issue, homelessness feeding trespass tickets, feeding jail time. With Williams, it was sharp focus on bond conditions and the seriousness of reoffending while already under court supervision. In both, Middleton's style shone through, a little dry commentary, a lot of procedural clarity, and an insistence that accountability, however imperfect, has to be the through line. Time to break this one down. Judge Middleton balanced pragmatism with firm accountability, giving one man credit for time served in a cycle the system can't fix, and another a sobering reminder that bond violations and new charges only tighten the noose. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.